A recent legal twist just came out of the Fifth Circuit Court of Appeals, and it's a big one. The earlier ruling that declared suppressors aren't considered arms under the Second Amendment has officially been pulled back. That original decision has now been vacated, and it comes after the Trump-era Department of Justice reversed its stance and acknowledged that suppressors do fall under the definition of protected arms. According to the latest from the court, the case has now been declared moot. So let's dig into what that means and where this situation is headed. Now, before we get into the legal meat of it, let me say this real quick. If you're tuning in here, chances are you're someone who values your Second Amendment rights. But here's the truth. Even the most responsible gun owners are getting caught up in legal trouble for things they didn't even know were wrong. In this video, we're looking at a federal case called United States versus Peterson. This is the same case that went in front of a 3-judge panel in the Fifth Circuit, which originally ruled that suppressors do not qualify as arms and therefore are not protected under the Second Amendment. That was a major blow to gun rights at the time. Mr. Peterson had appealed his conviction under the National Firearms Act, arguing that the suppressor regulations imposed by the NFA were unconstitutional. Initially, the panel shot down that argument, claiming suppressors aren't arms in the legal sense. But then something major happened. Pam Bondi, speaking on behalf of the Trump Department of Justice, filed a new brief with the court arguing the exact opposite, that suppressors are protected as arms and that neither states nor the federal government can impose a complete ban on them. They made a point to say that while the NFA imposes restrictions, it doesn't amount to an outright prohibition, so it's still within constitutional bounds. However, the DOJ also asked the Fifth Circuit to walk back their earlier conclusion that suppressors don't count as protected arms. That was a pretty dramatic shift from the government's earlier position, and the court took notice. In direct response, the same 3-judge panel that made the original ruling has now pulled their previous opinion. What does that tell us? Most likely, the panel is going to take another look at the case and reconsider whether suppressors do, in fact, fall under Second Amendment protections and whether the NFA restrictions are constitutional at all. That theory is backed up by a new update from the Fifth Circuit en banc panel, which has declared the rehearing petition officially moot because the original ruling is no longer in play. In plain English, since the 3-judge panel withdrew their opinion, the broader panel won't weigh in. The case now stays with those original 3 judges. So that's where things stand. The initial decision that undercut suppressor rights is off the books, and a fresh ruling could be on the way. Whether or not suppressors will be officially recognized as arms under the Second Amendment is still up in the air, but one thing is certain: this fight isn't over. For those who might not be fully up to speed, here's what happened in this case. Back in the year 2022, federal and state law enforcement officers executed a search warrant at Mr. Peterson's residence in Louisiana. The operation involved a joint task force made up of around 50 officers, including federal agents from the Bureau of Alcohol, Tobacco, Firearms, and Explosives. The search stemmed from concerns over Mr. Peterson's handling of a small firearms business he was reportedly running on his property. According to the ATF, there were several problems: allegations of straw purchases, questionable record-keeping practices, and issues tied to Form 4473 documents. A particularly serious claim was that some of the firearms sold through Peterson's operation later turned up at crime scenes. But here's the twist: the legal battle that followed wasn't sparked by those broader accusations. It all came down to one item: a solvent trap found during the search. That single item became the focal point of the National Firearms Act violation and kicked off the Second Amendment legal challenge. Mr. Peterson responded by filing a motion to dismiss the charge, arguing that owning the item was protected under the Second Amendment. The trial court wasn't convinced and denied the motion, which led him to appeal that decision to the Fifth Circuit Court of Appeals. When the case reached the Fifth Circuit, a three-judge panel ultimately sided with the ATF and, at that time, the Biden administration. The court rejected Mr. Peterson's constitutional defense and ruled that suppressors, in their view, did not qualify as arms protected by the Second Amendment. In their opinion, the judges noted that this was the first time the court had directly addressed whether suppressors qualify as protected arms, and they pointed out that every other court that had looked into the issue had also ruled against that interpretation. The panel reasoned through a historical and functional lens, asking whether a suppressor qualifies as an instrument of attack or a means of defense, or whether it is used to strike or project force. They concluded that it does not. The opinion argued that while Mr. Peterson viewed suppressors as essential components of firearms and therefore deserving of protection, the court disagreed. The judges stated that a suppressor, on its own, is not a weapon, does not function independently, and cannot be used for self-defense unless physically thrown. Because it lacks independent utility, they argued it did not meet the threshold to qualify as an arm under the Second Amendment. The panel then determined that suppressors are not crucial to the operation of a firearm and therefore do not warrant constitutional protection. With that, the original ruling from the lower court was upheld. Mr. Peterson's legal team wasn't done yet. They filed a petition asking the full Fifth Circuit, meaning the en banc panel, to rehear the case. Initially, the Department of Justice, still staffed with holdovers from the Biden era, maintained the position that suppressors were not constitutionally protected. But that stance changed when the case caught the attention of the Trump administration's Second Amendment Task Force, led by Pam Bondi. In a revised brief, the Trump DOJ stated clearly that the federal government now believes that accessories and components like suppressors are, in fact, covered under the Second Amendment. According to the new brief, banning such items would be unconstitutional because it places an undue burden on the right to keep and bear arms. The document specifically admitted that the government's earlier position had been mistaken. However, the DOJ also made a nuanced argument. While affirming that outright bans would be unconstitutional, they defended the National Firearms Act's current system of registration and taxation for suppressors. They claimed this framework imposes only a modest burden and fits within America's legal traditions, especially given that suppressors can be misused in criminal contexts. Based on this logic, the DOJ agreed with the conviction, but asked the original three-judge panel, not the full court, to revisit its reasoning. They said that while the panel got the outcome correct, some of the constitutional analysis was flawed and needed to be revised. Their recommendation was that a full en banc rehearing wasn't necessary. Instead, they urged the same panel to reconsider the opinion and issue a revised ruling that better reflects the updated legal view. Well, it looks like that's exactly the direction things are heading. The Fifth Circuit just released an official order indicating that their prior ruling on suppressors has been formally withdrawn. The notice specifically stated that, in accordance with the court's directive, the opinion in this matter has been vacated. Now, what does that mean in practical terms? It could signal a few different possibilities, but the most likely scenario is that the original three-judge panel is clearing the way to issue a fresh opinion. And based on everything we've seen, including the new legal arguments brought forward by the Trump administration and the shift in the Department of Justice's stance, that seems to be exactly where this is going. Adding another layer to this whole situation is the recent movement on the Hearing Protection Act. The updated version of the bill, sometimes called the Big Beautiful Bill, was just folded back into a broader legislative package. It successfully passed through the Senate, made it past the parliamentarian review, and was approved in a full vote. But here's the catch. This version of the HPA doesn't go as far as we hoped. Instead of fully removing suppressors from the National Firearms Act, this iteration merely drops the transfer tax from $200 down to $0. So while it's a symbolic step forward, it doesn't eliminate the registry, the paperwork, or the federal control over suppressor ownership. That full repeal is still out of reach for now. It'll be important to see how this development affects the legal landscape moving forward, especially with ongoing lawsuits like the Peterson case, and another suppressor-related challenge currently sitting before the United States Supreme Court. There's a lot in motion right now between shifting legal arguments, changes in federal policy, and actions in Congress. It's a pivotal time for suppressor owners and Second Amendment supporters alike. As more updates come in, I'll keep you all informed. If you'd like to support the channel and the work one do here, one of the best ways to help out is by visiting my website, armscholar.com. You'll find a ton of valuable info there, including that free legal survival guide, one put together for responsible gun owners. We've also got some gear, merch, and curated deals to help you save a few bucks on your next purchase. Again, that's armscholar.com if you want to check it out. Thanks so much for sticking around. Don't forget to like, comment, and subscribe to stay in the loop. And remember, this country was founded by scholars, and it's going to be preserved by scholars.